So we've kind of gone two directions in this whole discussion. One of them is the political side, and the other is the technical side. They're tied, of course, because the idea was that we'd address some of the political issues with the technical course corrections. Now, it's been made abundantly clear that much of this was done in a way that doesn't necessarily benefit cities, doesn't necessarily benefit the developer, mainly because these things are most often show up in the land use context, and other areas that may benefit the public and make it more transparent and understandable. But there's no question about the complexity, and hats off to the county clerks, the city clerks, recorders, others, the city attorneys and county attorneys that have to deal with this. But where do you think this leaves us, Cameron, as we get started wrapping it up? Do you see where is this going? What's going to change? What's going to happen? How long do we have to let this settle in before there'll be more discussion at the legislature? Where are we anyway?
There were a lot of questions there, Craig. First things first, the legislature starts their interim meetings tomorrow. And as the case with every piece of complex legislation, I anticipate that over the next few months, as it starts to get implemented, there'll be things we didn't consider. There'll be lessons that will arise, and that's good. Hopefully, one of the takeaways you have from today is that Representative Diehl is a team player and is someone who is seeking balance in this bill, and as we all gain experience on it, is going to be willing to come back and make some potential changes. Now, the bigger question that you're asking, Craig, is where does this take us as a community in general? And I think we're seeing more and more local referendums, not just in the land use context, but in general. And that's in part because in 2019, it's easier to organize. It's easier to organize via social media. It's easier to communicate. It's easier for people who are frustrated with the status quo to raise their voices. There was a lot of conversation during the legislative session about quote unquote propaganda and inaccurate information. And fortunately and unfortunately, with the First Amendment, you're always going to have inaccurate information. That's been the story of the country for the last 200 plus years. Hopefully what we've achieved though in House Bill 119 is the ability to combat inaccurate or incomplete information with the full story and allowing elected officials in cities to explain themselves. So I think we'll continue to see referendums. It'll be interesting to see what the impact will be of voter participation areas going forward. I think direct democracy, based on what we saw statewide last year, has a lot of momentum behind it, but we think House Bill 119 helps to try to keep some balance between local elected officials and the people who they've been elected to represent.
Well, so this is the question. We've spent a lot of time talking about the politics, some of the mechanics. In your mind, what's the future? What's going to happen next in the area of referenda and initiative? And Renae, by the way, is with the firm of Foxley, Pignanelli, a public interest firm. They do a lot of lobbying on the Hill during the legislature and involved a lot. They're so involved, in fact, let me ask you this question, Renae. I mean, granted, you're a powerful state lobbyist, but how do you end up on the front page of the newspaper holding the spike on the sesquicentennial?
We have our hands in a great many pots. So, I know you were all there, right? May 10th, Promontory Summit. I saw all of you there, I'm sure. So the firm Fox Pignanelli engaged in a great many things. Honored to be affiliated with a premier lobbying firm here in Utah. Additionally, we have now run 3 successful campaigns thwarting local referenda. So we're the only ones to have done so in the state at a local level. So there have been some that have defeated them statewide, but we're the only firm that has done so locally. So having kind of been in the trenches on this and kind of seeing the front lines of what's happening on this level, a couple things. Cameron's right that that HB 119 has kind of change the landscape a little bit in terms of providing clarity for cities, preserving a couple First Amendment rights, and kind of clarifying some issues. But additionally, it's modernized the process. We're in 2019. There is no reason why you shouldn't be able to electronically submit certain things. There is no reason why we should have these long delays of you know, looking at like paper packets. Like there's no reason for a couple of these things. And a lot of things have changed because of SB 54. Now, anyone in this room, we all know what SB 54 is a handful of years ago. What SB 54 did is it created a industry around signature gathering and around professional canvassing. So Utah now has 3 permanent companies here locally in Utah, because you have to be a Utah resident in order to collect these signatures. There are 3 companies in Utah that now professionally do this full time. And they have their team of canvassers, and they recruit, and they find these cute return missionaries and summer sales guys that are home for the fall, going to school, and they will recruit them to go do these door-to-door. They will either get signatures, or you can hire them to remove signatures or otherwise. But SB 54 has created this permanent industry, which has made it easier for these residents and these activists to hire these firms and to get on the ballot much easier than they would have otherwise. And so that, more than anything, has changed the referendum process. Now, 119 has modernized what that process looks like, but they're not going away. Because of the permanent industry now that exists in Utah around signature gathering, local referenda and initiatives are not going away anytime soon. I think that our state legislature would not like to see the state turn into California, where we govern by initiative and referenda, but because of that industry, we are trending that direction. When you look even statewide, things have changed so dramatically because of this industry. How many initiatives, filed to be on the ballot? How many were this close? And how many made it on the ballot versus what, does anyone know when the last one was? It was like 2001, and it was like a school thing. It was school funding, I believe, but they have been few and far between, again, until now we have this permanent industry.
Can I add one more thing?
Sure, Kevin.
I just want to piggyback on something Renae said and give you an example of what's actually happening in California, not just for governing, but for leverage. Now, I feel like I'm going to be the bearer of bad news here, but I think this was a fascinating example from my counterpart at the California League of Cities. They were negotiating a bill at the State House, and they were negotiating it with both lawmakers and a private sector entity. And the issue had to do with soda taxes, but the issue is not really important. It's more the tactics that are important. So the cities were looking for this certain type of authority, and they were looking for the legislature to grant them this authority. The industry said, not only do we oppose you at the Capitol, but we are going to go gather signatures, and we're going to label our ballot initiative the no taxes on food initiative, and we will get this passed. And not only will you not get the authority you're looking for, but we're going to repeal some of the authority you currently have. And that was the point where the California League finally had to throw their hands up and say, it's not worth it to us anymore. And then the legislature ended up preempting the California League in this space, but not as far as the initiative would have gone. Now, that was for a statewide initiative, but when Renae talks about the Californication of referendums and initiatives, what is happening in California is it's becoming part of this leverage for political negotiation, which should send a shudder down all of our spines as local government. At what point does just the threat of initiative or the threat of referendum start to change policymaking? Again, that's where I think House Bill 119 does a good job of trying to balance the constitutional right of citizens to have their voices heard and to push back on decisions they disagree with that local government has made, while also still allowing those elected officials to explain why they vote the way they vote.
Gary, where are you in this discussion?
Just so you all know, under your seats is a number, and according to that number, there's a door prize. And the door prize is the development agreement, the master development agreement Ivory actually was approved on, that was not subject to referendum. It's worth a mint. A lot of money was spent on getting that passed. I think I'm here because Layton was one of the first losers in the referendum process. We had 107 acres out in West Layton that was owned by the LDS Church, for heaven's sakes. Who doesn't vote in favor of an LDS Church project? If it was a temple, I think we probably would have made it, but it was 107 acres of mixed use out in West Layton. Interestingly enough, when the referendum folks first began to organize, we thought there's no way they're going to be able to pull this off. They're not going to be able to get the number of signatures. That was the first thing we thought. There's no way they're going to be able to get the number of signatures. Well, they did, and they got them very, very quickly. And we discovered that there are companies that Renae has talked about out there, 3 in Utah. There was one more, Renae, with Silver Bullet that helped the guys out west. Is one of the 3, okay. Yeah. And they've got a presence here. They had an individual. He must have been just a local sales guy that worked out of his home in Murray, and watched the Tribune and the Deseret News to see when there was a controversial issue that came up, and then he would jump on the folks that were involved in that controversial issue, and they can gather signatures faster than anybody. When the incentive is money, they can gather signatures very, very quickly. Not only that, but they had web pages that were phenomenal. I've never been able to reproduce anything like that. And when we tried to trace the origin of those web pages, we were taken all the way back to a little company in Florida that actually, they had just folks sitting in the back room, just all they did was make web pages. They didn't care what the issue was. They were awesome web pages. They had a rolling script across the top of what your neighbors were saying about the referendum the entire time that the referendum signatures were being collected. They produced and this was the most offensive part, the voter information pamphlet that we put out. They refused to give us any information to submit for the voter information pamphlet. And then after we had put a voter information pamphlet on every door in the city, essentially hung one on every door in the city, they came back with their own voter information pamphlet, which looked just like ours, and it said amended voter information pamphlet, and they posted it on every single door in the city. And so these were the things that, to me, I mean, I understand and I feel very strongly about the people's right to be able to vote on an issue. But the thing that is not fair is that the city had to remain silent while all of that was happening. We couldn't say a word. We couldn't advocate at all. And Brad Daw, I can tell you just a little bit about how much they paid per signature in the state of Utah for the 3 referendums they had on the ballot in 2018. They paid $4.19 for the marijuana proposition. They paid $11.75 for the healthcare proposition, and they paid $9.19 for the redistricting measure. In Layton City, they paid approximately $4 per signature for the signatures that they collected in Layton. So it was a pretty cheap deal. It was around $3,000 that they paid for everything that they got from Silver Bullet. So I guess what I'm saying is, if you think that they're not going to be able to accomplish the acquiring of signatures, forget it. That's already passed. It's an institution, it's a cottage industry, and they're able to gather those signatures quickly. If you think that they're not going to be able to do the sophisticated website that will essentially knock yours out of the ballpark, forget it, because that's included in the cost. And they'll do that website and people will go to it and they'll think that it's actually sponsored. This one looked like it was sponsored by us, but it was not. And then, so I guess what I'm saying is, just the takeaway from this entire conference is, number one is don't take the opposition, and I do call them opposition. And the reason I call them opposition is because, unlike an initiative, a referendum is challenging a decision that our local officials have made, and they're supposed to be co-equally weighed, is what they're supposed to be. They're supposed to be on an equal basis. One of the justices slipped in one of his opinions and indicated that he thought the referendum, or the people's right, was just a little bit above your elected officials' rights. That was a comment in one of the opinions. And then several years ago, we as city attorneys were sitting down, I think it was downstairs in a Moab, a cheap little Moab hotel when we didn't have very many of us. And we had Justice Wilkins come down, and we had him talk to us. And he said, on referendum, he says, if any of you city attorneys are thinking of challenging a referendum, he says, forget it. Because he says, whatever you give us, we're going to vote in favor of the people. And that was a comment from a justice who had just barely retired, but it reflected everything I have seen happen, including Craig's case and others. I mean, I'm not saying it was deliberately done, but I'm thinking about the timing of the opinion of the court relative to the validity of the ballot. It occurred after the vote had been taken by the people. And I've often thought, you know, I understand that there were a lot of complicated issues and that type of thing, but really, is the Supreme Court in the state of Utah really going to make a decision contrary to when a bunch of citizens have voted in favor of it, when they've got that kind of sentiment essentially towards referendum? And I'm not disparaging the court, I'm just saying that that's the way they think. They think that we're going to decide that whatever this situation is, we're going to do everything we can to make it a valid referendum so that people can have a valid vote and counteract what the elected officials are doing. So that's the first takeaway, is if you think it's ended here, it started about 5 to 6 years ago, and it's just built ever since, and every single decision that comes down, whether the Suarez case was a development agreement with a few things in it that looked like they might be legislative type of things. And the Cottonwood case, the same thing. It was a development agreement that essentially was a site plan agreement that tended to have some things that looked like they might be able to be interpreted. That was a big stretch, in my opinion. If this would have been determined 10 years ago, this would never have been a legislative decision. It would have been an administrative decision without a doubt. But it has gone farther and farther and farther, and I see the day when it doesn't matter what you submit to the court, they're going to find that it's essentially a legislative body. Another takeaway from this is be ready. You know, you got an EOC whenever an emergency happens, and you've gone through practices, EOC practices in your cities. This is an EOC. It has to be organized long before the referendum takes place, because if you wait till it takes place, you're going to be lost. You're done. And the clerk needs to, the recorder needs to know what happens, the city attorney needs to know what he needs to do, or she needs to do, and the council need to know what they need to do. So all of that has to be orchestrated long before your first referendum occurs in your city. And then just a couple of other small things is developers, start thinking way, way ahead of your projects, all the way back to the days that they're actually financed. Because if you're financing something based on the highest density, which we've had some come in and say, well, you know, we planned on this density. If we don't get this density, then we're not going to be able to fund this project. And you know, what you need to do is you need to take a look at it a long ways in advance and understand that the decision on your property, the property you're going to purchase, may be subject to referendum. There may be compromise involved, and just take that for granted up front, and the compromise is probably going to be centered around density or intensity of the use. Anyway, those are my 2 bits on it. Having gone through it, the trauma of it, I still have PTSD. I wake up at nights in a cold sweat, but I think I'm getting over it after all these years. So.
Yeah, thanks so much. I just want to highlight a couple of things real quickly. As many of you know, and as we mentioned in the prior panel, some of us were involved with the Cowley Mall matter, which is the most recent matter, at least to go to the court. And I agree with what Gary had said. If we were faced with the case law that existed 10 years ago, it wouldn't have been a close call. And it is true that the court indicated in that footnote, as I indicated, that they were debating amongst themselves as to where they would draw the line as between administrative and legislative. But in the end, Lady Justice kind of lifted her blindfold and peeked and looked at the election results. And once that happened, they just decided to issue an opinion saying, okay, in this case, we'll just determine it to be referable. And as a result, the election result stands, and there you go. Now, so that's one example. That's an example of a developer choosing, in that case, to fight and determine whether it was referable or not. That was a court case. Now, I think a lot of the changes that were done in HB 119 will help in setting that discussion up earlier, and hopefully you won't have as much dispute leading up to it. In other words, you can get those issues of referability analyzed and addressed earlier. That will be a good result. But that's one way where the developer chose not to engage in campaigning. The developer did not engage with the public, and the reason is because they were saying this wasn't referable. They were putting all of their bets, if you will, on the court in that instance. Fast forward 3 months further, so back into March of this year. Same developer, but a different situation. We were in Cottonwood Heights, and we got an approval. This is a classic performance zoning. We went and did what they call in Cottonwood Heights a PDD zone, which is a performance zone. And what it meant is if we provided certain incentives and certain public amenities, then we could get increased density. It was marginally increased. And what's interesting about this was a 5-acre site, 200 units, adjoined on 3 sides by apartments. The 4th side's an interstate, okay? We got referred. People referred over that particular project. And in that instance, rather than doing as we did and argued referability, because there are still some arguments and we still want to fix the case law, but rather than go down that path and making legal arguments, we hired Foxley Pignanelli and decided to do the other thing, which is to engage the public, which talks about the websites, which talks about hiring your own folks, which talks about engaging the public and getting that information out so that you don't have just one side of the story being told on the doorstep. And as Cameron indicated, we did a presentation last week to the city attorneys. And in that presentation, the city attorney for Holiday, Todd Godfrey, spoke a little bit about the experience Holiday had from a city perspective. And one of the things that he explained, so that some of you will have heard this already once, was that he happened to live in Holiday City, far removed from the Holiday site, but he engaged a signature gatherer on his porch one evening. And as that signature gatherer was speaking to him, he counted off no less than 9 factually incorrect statements by that person. And he sat there and kept that signature gatherer for an hour and talked to them about, why these things weren't as being represented. But the fact of the matter is that the public, when they're addressed on their porch, they're not wanting to engage in a large dialogue to figure out what's true and what's not. They just want a statement of what's the issue and decide whether they want to sign or not. And oftentimes we found that people will just sign to get you off their porch, right? So for a developer to sit back and just think, oh, everything will work out, that's not the right way to do it. You have to get engaged early, and you have to plan on being engaged with the public at least two phases. I always argue, because my practice is an entitlement practice, that you engage the public early in obtaining the entitlements. But if you're being referred, you're recognizing that that was not completely successful. So now you have 2 more opportunities to engage in the public, potentially. One is at the signature gathering phase, which is what we did in Cotwood Heights, and I'll let Renae speak a little bit more about that. But in that instance, you're getting the word out, like I said. The other is you need to be prepared to engage later on if signatures are obtained. So say, for instance, sufficient signatures are obtained because you've got enough of these hired signature gatherers out there, and they've talked to enough people at the library or at the grocery store or at the church, and they've got all the signatures that they need to get it on the ballot. The game's not over then. There is time then to go and actually argue the merits and argue why this project's beneficial to the community and so forth. So I think that's something that when you're seeing a developer bring in a project, maybe of a certain size or a certain sophistication, or where it's going to have a high risk of being referred, you need to make sure that the developer's thinking ahead of time as to what will be their referendum game plan. And it's not something you can just simply wing. You just as Gary's suggesting that cities need to have an action plan, developers need to be developing their own action plan to address this. Now, do I think this is am I liking that this is the way we're going? Not at all. I think that so much of what cities do should be deemed as administrative, particularly when you're dealing on a parcel by parcel basis. And the reason from a policy standpoint is it shouldn't be a popularity contest as to whether you can get your property developed, but that's what it's becoming. And in the case of Holiday, and these aren't my words, but I'll just recite them because they were said by that prior panel last week. In that case, you had, centimillionaires ganging up on one other centimillionaire, and it was a battle of titans, right, to see who could outpay out. And as a result, the city gets to get involved in that process. Unfortunately, if there's ever a taking claim, you know who's the one who's going to be looked to be paying that claim while citizens are out gathering signatures? It's the city. So I'm typically not viewed as being hyper sympathetic to cities, but in this instance, I recognize the conundrum that this process is putting, or the pressure rather, that this process is putting on cities. And so developers and cities need to work very closely together to make sure that they're anticipating these things so they're well positioned to avoid them. But I just want to leave with this comment so you don't feel doom and gloom. If you get the information out and if you have effective communicators, more often than not, that the right argument will win. But what you can't do is just expect the right argument to be, magically materialized. It really needs to be communicated through effort. And so I'll just end this first round of comments with that thought.
Super. Thank you. Comments, questions that you might have?
The only case I can think of recently that has found that an administrative act as opposed to a legislative act is the Provo City BRT case. Does that provide us any hope at all, or was that such a slam dunk that it really doesn't help us too much?
I was not involved with Provo City BRT, and we certainly cited a lot in our case, in our brief. I mean, in that instance, there were some peculiarities where the way that it was staged on an extraordinary writ up to the court led to the result where the issue of whether it was going to be challenged or not, it became moot by the time it got before a court. And we've tried to address that with HB 119 and have tried to encourage, at least in the land use context, that the Supreme Court keep disputes over land use matters, because what happened in the BRT case, it got remanded, and by the time that it was going to be eligible for an election, the road was already completed. And so basically what you had is a situation where the project was going forward, and the issue of whether it was administrative or not got delayed because the court said the district court should be the one to go build us a record and determine whether it's referable or not. I don't know if that's answering your question, but that one had a peculiar footing, at least with respect to the way that the case was teed up. And in the case of HB 119, what we've said is during the pause, if there's a dispute, what you do is you bring that challenge immediately as soon as the dispute materializes within that first, is it 30 days? 20 days, yes, sorry, 20 days. So if there's a dispute, then you go on an extraordinary writ to the Supreme Court. And so whether the Supreme Court's going to try and then say, well, the legislature didn't have authority to tell us that we have to take this case, we'll see. But as opposed to the statute and what the language that we use for other matters like local laws, for land use laws, we're trying to carve it out and make it a little bit more special so they'll keep it. We'll see if that works.
So my take on it is there are 26 states since as far back as you can remember that have adopted some type of referendum or initiative process. This last year, 21 of them had initiatives or referendums. There was a time when you couldn't even count one or two that actually used those for any other purpose other than a very desperate purpose. So it's becoming more and more common, and the number of referendums is increasing exponentially, especially in states like California. And so I think the trend is to see these growing. The encouraging thing is we haven't seen any new states adopt either a constitutional amendment or a statutory provision that actually provides for this. So maybe there's a balance, happening on a national level. But as far as we're concerned, I think we have pushed about as far as we can legally. I think if we were to push further, I think Cameron and Representative Diehl and Renae and the others that worked on this have pushed as far as we are legally going to be able to push in the state. I'm looking at a couple of other things that some states have done to try and push just a little bit further. The distribution is the first one, and we fixed that because of the distribution areas or the districts that you've provided for. But eliminating the pay per signature, there's some states that have banned that. Some of those 26 states have banned you can't pay for signatures. There's a restriction on the circulators, on who can circulate petitions. They keep a tight rope on that so that you don't have a whole bunch of companies coming in and inundating a state and essentially taking over. Initiative petition circulation periods, adjusting those circulation periods of how long you've got to circulate a petition, making it a little bit more difficult in that regard. But I think, just looking at this court, I'm going to warn you that I don't think that any of those, I think we've gone as far as we're probably going to be able to go. As far as what Cameron said regarding what's happening in California and the threat of referendum initiative, I can tell you that the threat level has gone way up for developers, and there are many developers now that will come to the city, and that's almost one of the first questions they ask is, what level do you think this is as far as being subject to referendum? How much opposition do you think we're going to receive as a result of this? And then we start strategizing together as to how we're going to accomplish it. So it's just a fact of life today in the state of Utah that if you have a development company in land use in the state of Utah, you're going to be subject to referendum, and very likely, I mean, for heaven's sakes, the other day we have 2 trails that converge. We have one railroad trail that converges, and another trail that comes from another direction. And we have a little piece of property where we thought we'd just put a couple of benches for the joggers and that type of thing, and put a little restroom there. And I'll be darned if they're not threatening a referendum on a toilet, on a small toilet that they're putting at that one little corner of the parkway. And it's a logical place for a toilet, for heaven's sakes. But they're saying they can always go down to Smith's. So there's their argument at the front door. They're already couching their arguments in favor of alternatives. Anyway, yeah, anything is subject to referendum, and so I think that threat is here to stay. I don't think we're going to use that.
One thing to add to your question is you're really asking, what is the climate in the courts for a referendum going forward, and is there something we can build on from the handful of cases that have gone our way? And I think that's a very fair question to ask, and it's one that within the league and within the Municipal Attorneys Association we're starting to ask. By a quick show of hands, how many people here are attorneys? Okay, so quite a few. House Bill 119 was a legislative approach, but we do need to just have more collective conversations about legal arguments and amicus briefs and other things, so that the court has more to consider. We've talked how can we educate judges or help inform judges about the distinction of legislative and administrative, particularly in local government where there are multiple types of forms of government, and that gets complicated. It's not what you learned in 5th grade with a clear cut, here's the executive branch, here's the legislative branch, with a handful of exceptions like Murray or Salt Lake or South Salt Lake. Most of them, the city council can exercise both functions. And so we've had the discussion internally of what can we do within the judicial system, and we're certainly open to suggestions as potential cases come forward.
Other question?
Do you think there'll be any legal challenges to HB 119, maybe to the voter participation districts?
Yeah, we do. In fact, this came up during the session. And you heard Ryan Cowley during his presentation reference the fact that this year could be a little tricky because precincts were not drawn with voter participation areas in mind. We went back and forth with legislative research over whether or not to create voter participation areas using the one-man, one-vote standard, which is what you have to do for state senate districts or congressional districts, or if we could create a new standard that isn't necessarily the same threshold as one man, one vote, but would grant a little more flexibility for the drawing of these districts, because the drawing of these districts is not for the actual vote, it's for access to the ballot. There's no court case in Utah on point, but there is some jurisprudence within the 10th Circuit in Colorado where the court is looking to distinguish between the access to the ballot versus the actual vote, and the one man, one vote standard applying to the actual vote. So moral of the story is there's a vacuum of jurisprudence on this. You have a bill that creates some potential controversy, so we do expect at some point some litigation. Now, I think once the 2020 census is finished and we're redrawing maps in 2021, that it will make any arguments against an equal protection argument easier for us, because the precincts will be drawn with VPAs in mind. But I do think that VPAs could be open to a challenge over the next year and a half. That's why when Wade and I were talking about it before, I referenced the fact that state law has geographic diversity, and we tried to match state law as best as we could, and even have a lower threshold than state law from 90% down to 75%. So we're prepared for a potential challenge on that piece. On the communication piece, I think a challenge could come if people get cute. Now, the definition of cute varies on who you are, right? But we've tried to be clear with these exceptions in the code about how you can communicate with residents, and inevitably somebody's going to disagree with that. but it will go to the Lieutenant Governor's office for adjudication, and there'll be actual due process there, whereas now you don't really have that, which then leads to bad facts, and bad facts make bad law. So hopefully by having that due process at the Lieutenant Governor level, we can preempt some potential litigation there too.
So yeah, Cameron's absolutely right. If this law is going to be challenged, it'll be in those two issues. But let me just take a quick minute to say why these voter participation areas and the geographic diversity is so important. So as Cameron mentioned, we tried to mirror statewide standards. We tried to bring this a little bit more into line with what they do at the statewide referenda and initiative level. And another one of those things was removing the requirement of having a notary sign the signature removal forms. Again, this is 2019. They don't need a notary to get their signature on the petition. Why should they need a notary to get their signature off? But these voter participation districts are so significant. I'll give you an example, and that was Orem. So we just defeated that referenda on the ballot in Orem to build some student housing units. And the area surrounding UVU is some older communities, right? These people have lived there for 30 years. They have seen from UVSC all the way to a 30,000 student population. They are very ticked off at the growth in their older neighborhood. So they were extremely passionate about this issue, but you had maybe 2.5 precincts that passionately cared about this issue. The rest of the city of Orem were big supporters of UVU, and they could really care less about student housing as long as it did not adversely affect traffic. That was the only reason why they would be in support of this. Many of their students would someday go to UVU and otherwise. So the geographic diversity would have been significant in the signature gathering phase there in Orem. So that part's highly significant. The other part that again, Ms. Cameron said, if someone tries to get a little bit cute on the communication piece, then perhaps there could be a challenge there. But this was significant also to protect the First Amendment rights of our elected officials. They are elected officials, and they are also citizens and candidates. And that duality of this role is important to protect. So in the administrative legislative acts that they're doing, they have certain standards they need to abide by. But as residents of a city, as candidates running for office, they need to be able to exercise their First Amendment rights as well, utilizing their own resources, their campaign resources, their campaign Facebook page, whatever these other avenues may be. We need to protect their First Amendment rights as well. And so that's going to be an area that, depending on how this falls and kind of some cases that happen and whoever gets a referendum filed next, the lottery in the room, how that's all going to kind of pan out in terms of the next legal challenge of 119.
Another question?
About communicating elected officials and using their Gmail, not their city. That is still an elected official discussing city business. Is it subject to grandma?
I really want to make a joke about your history dealing with grandma in your city, but I just can't go there. It's still too soon, right? So, quick show of hands, how many clerks and recorders do we still have here? Yeah, you're all asking that question in your head. Kalina's just the one who asked it out loud. So yes, it would still be subject to grandma if you're discussing city business on your Gmail account. You just want to be violating the Political Activities of Public Entities Act by using your Gmail account to explain information about the referendum. And more importantly, you would not violate the Political Activities of Public Entities Act if you used your cedarhills.org email address to answer questions or to communicate with a developer who owns the property that's subject to a land use referendum, or to communicate with your outside legal counsel about the referendum. You could do all those things with your public email that before, arguably, you couldn't. And even if legally you could, most people didn't because they were concerned about facing the fine and going down that rabbit hole. And so by spelling out those exceptions in the code, hopefully it provides more comfort for elected officials to conduct city business and city officials to conduct city business. And then when you step away from those exceptions, you can still use your Gmail account, recognizing it's subject to the grandma, but that's okay because ultimately you're using that Gmail account to communicate with the residents.
So speaking of it being 2019, social media is a very huge way that cities communicate with our residents. So I'm very curious, the idea of how we can
answer direct questions, especially when it pertains to, there's the city social media account, but then there's also the city watchdog social media account, right? That a lot of people are commenting on. So I'm curious about that.
Talk about next door. I mean, so speaking about social media, you definitely need an expert to advise you on that. I mean, one of the things that happened in Holiday, I'm not sure to what extent happened in Cottonwood, is you had an app called Nextdoor, which just travels like wildfire throughout your neighborhood. And it's not something that, you can't just log online. You have to show that you're within some certain proximity of your other neighbor. But you would get all kinds of communication through that kind of social media about the project. And a lot of times, as we've said in prior panels and in this panel, it's misinformation. And so having your own campaign to get out there to get the correct information is critical. I'll just jump now to Cottonwood Heights. In Cottonwood Heights, I grew up in that area. I went to school there. And so I had family members and friends and people I hadn't heard from in 20 years, 30 years, calling me about that. And they were saying things such as, as I described earlier, this was an apartment building next to I-215. They were calling me saying, my neighbor is telling me this apartment building is on the foothill next to the canyon going up a snowbird. Or this is next door on an empty lot next to my church. I mean, and where are they getting these rumors? They're getting them through social media, these websites, or the signature gatherers who are saying whatever they can to get their $5, $10, or $12, or $13 per signature. So I don't know. I think that's something that you have to have in mind is how can you get the information out? And I think from the city's perspective, I think Cameron's efforts can't be overstated. His seeing this as an important thing and ungagging you, if I may. And allowing you to at least get facts out there is key. But you can't just rely solely on that. There has to be more that has to be communicated too.
And Aaron, you ask a question that does require a lengthy answer. So let me summarize it. I appreciate what Wade said about the apps that exist above and beyond what you would ever want to codify. And we had this conversation multiple times with Representative Diehl that the code considers email. Yet email is so 1999. We all still use email, but the way we communicate is much broader than email. So there's language, and I quickly pulled it up. The inquiry language says, the section does not prohibit the reasonable expenditure of public funds to respond directly to an individual who makes an inquiry. Now, the original conversation we had was whether that should be tied directly to email, whether that should be tied to receiving a phone call, and I see people shaking their heads, and it was because we didn't want to go down the rabbit hole of trying to define 2019 technology in the code, and then come 2020, the new app that Wade invents and makes it big, all of a sudden it's like, well, can we communicate via the neighbor app, or can we communicate via Instagram or Picket? So the short answer is, whatever means of communication that you receive the inquiry, you can respond through that inquiry. So in your hypothetical, you had Highland City's Facebook page, and you had the Watchdogs of Highland City Facebook page. Well, on the Highland City Facebook page, you're using public funds on that, so you've got the framework for how you can engage on that page. But if that other page asks you a direct question, as Aaron Wells, Assistant City Manager, or Rod Mann, Mayor of Highland, you can respond on that page because you're responding to the direct inquiry. Now, what you probably can't do is proactively go to the Watchdog Facebook group and post all of this information. But what Mayor Mann could do is on Mayor Mann's Facebook page, link to all of the information that the city has gathered during that period of time, link to cover himself, link to what the referendum organizers have put together, and then say, hey, Highland residents, here's all the information, here you go. And then as people ask him questions, he can respond to those questions, and he's still protected by the statute. That's a short version of it, but my standard answer is always make sure you check with your legal counsel first.
But while we're on the subject of social media, again, I referenced this is 2019, we can use digital communication. We did some things in Orem that I was proud of digitally, but we really kicked that into high gear in the Cottonwood Heights campaign. And how many residents do we have in Cottonwood Heights?
We had to get 6,
No, how many total registered voters?
So the number we were based off of was, I'm sorry, thank you. I think it was around 35,000 residents, and so then the registered voter number was obviously a component of that. And the threshold we were trying to meet was around 6,300.
So we engage in some social media ads and some different things. We got Makai Johnson in the back row there who worked on this campaign as well and kind of headed up a lot of the social media strategy. So we did a lot on Facebook, a lot on YouTube and otherwise, geofence the city, set parameters over 18. And on our first 4 short YouTube videos, we did informational YouTube videos, we had over 30,000 views in that 45-day period. So once the state really modernizes and the organizers are able to collect signatures digitally and we're able to remove signatures digitally, that's gonna completely change the landscape all over again. Now that we can get people to, we can send them a form and they can print it out and remove a signature. We can do all that through social media, and we'll be doing a lot more of that. But social media is going to change the way that we're doing these referenda campaigns and fighting referenda campaigns. Under 119, it's going to change dramatically, and as well as the costs of these campaigns. I can't overestimate, or can't overstate, thank you, how expensive these campaigns are and how expensive they're going to be. This bill helps address that a little bit, but that's also one of the reasons why I think you're seeing an increase in some of these local referenda is that communication is expedited, it's immediate, and in these extremely short timelines of 45 days, that things have to happen very quickly. And because of social media and email and Facebook and YouTube and otherwise, this communication is happening so rapidly, they're able to organize quickly, and through apps like Nextdoor, you're just seeing more of it.
And just let me make the comment that to what Renae just said, the West Layton PAC communicated with the Kaysville PAC, which was actually voting against using electrical funds for it. Not even a related issue. But the two of them got together and they figured out that the West Layton PAC had been very, very successful. And so they gave them all the ideas that they had. And Kaysville used many of the same ideas and the same company and that type of thing in succeeding in theirs. So they're communicating too. These PACs are communicating around the state as well.
And the last thing I'll add, I found the other language I was looking for, is that the PIP can be distributed far and wide. And the PIP's the Proposition Information Pamphlet. So on the Watchdog Facebook page, the city could link the PIP there. And the PIP has the 500 words for and against, the fiscal analysis, legal analysis. You could post that there. It's all that additional communication that we've been talking about. That's what you want to proactively put there. But you could say, hey, here's the link to that additional information, link to the proponent's information. But the PIP is intended to be spread far and wide. And the language that we put in here says that the public entity can post basically on any medium a complete copy of a proposition information pamphlet. And so the term we use was any medium to try to capture the communication networks of today and tomorrow.
So really quick 2 items from me, and then I'll be quiet for a minute here. One is, with respect to PIP, I think it is key to link to it, but you can't think that alone will do the deal. Yeah. Because I would say out of most people we know, they aren't going to read even a PIP. What they're looking for is a much more short, concise statement of yes or no, white, yes or no. And that's why, again, I have to emphasize the importance of getting these people who are in the space of marketing and communicating and doing it in a way that people are used to consuming. They're used now to consuming information in tweets and things like that. And as a result, you need to have that as part of your plan. The second thing that I think is important for cities and for you to share with your city councils and other decision makers is that this bill is going to change the method for signature gathering in an important way. What we've seen in the past is you have a 45-day window, and what the opponents will do is they'll wait 15 days. They have a very quiet campaign. Then they can increasingly ramp it up to the end, and then they would go and drop off the packets on the 44th day. That then puts the developers in the cities at a big disadvantage, because how can you know who to go and get removals from? This law changes that because a signature, once it's obtained, expires in 7 days. You have 7 days to turn that into the county clerk. If you wait 8 days, that signature is no good. So what that then means is that people who are engaged to monitor these things are going to be asking the clerks every day for which signatures have been gathered. That then gives you a list of people to go and try and get those who just signed to now sign a removal. Now, we lobbied, at least on PRC side, which is property rights side, argued to say we should be able to turn in all the removals at the end, but we didn't get our way. And so our removals now expire within 7 days. So it's quite possible the opponents will then want to see our removals, and it will be a back and forth jockeying. Okay, so I'm not excited about that component, but I think it's important for us to know what is the reality being formed by this bill. And the reality is there's going to be hyper emphasis on whose names are being turned into the county within that 7-day period, and what kind of response do they get when they go and try and get a removal. So anyway, it's something to think about.
Can I add just maybe one last comment? There is another way to fight this. Cameron's indicated that we've got some more work to do in litigation. I agree with that, but I am very pessimistic about any future litigation before this court. But nonetheless, we will try. I think we've gone about as far as we can from the perspective of statutory amendments. And I think that might even be subject to challenge. But cities have to work smarter too. You have to take a look at your general plans. Here's an example. Recently in Layton, we knew that there was going to be a need for a transfer station. And is there a bigger issue than a trash transfer station in any jurisdiction, right? Long before that trash transfer station application came in, we looked through the city, we saw where we wanted to put it, and we determined that it should go in a manufacturing 3 zone, I think is what it was. And that it would be a permitted use in manufacturing 3 zone. And we rezoned a piece of property, manufacturing 3, in the upper left-hand corner of the city. It was a permitted use in the manufacturing 3 zone. The zone passed, the zone content of the zoning ordinance passed. And then all of a sudden what happens, Wasatch Integrated comes in and makes an application in the M3 zone for a transfer station. Permitted use, issued across the counter, administrative. And it was done. It was absolutely done. If you can do that for higher densities, we have to think smarter as cities is what we've got to do. We've got to look ahead. We've got to look at those areas that may likely go higher density, either as part of an overall zone change, for the entire city. That's what we're doing right now in what we call Layton Forward. We're looking at those areas where we do want that, and we will make these things permitted uses in those zones, so they just come in, they deal with staff, and that's it. And so I'm just saying there is another way to fight this on a city level, and it is by thinking ahead, looking at the best places for these zones to be, rezoning them, putting the zoning in place. Right now we've got an interesting phenomenon. We've got a development agreement with the church for 107 acres out west, and we've got a zone, MU, which is mixed use, and the zoning has been changed because at the time the referendum folks didn't understand that a single zone rezone, because at that time the court hadn't said anything, was actually a legislative act, not an administrative act, and so they didn't challenge that. So now we got a piece of property that's zoned MU, but they gutted the ordinance. They took the opportunity, because they knew what was coming in, to challenge the ordinance. If we passed that ordinance long before, can you see what would have happened? And made it permitted use, we'd have had it. So anyway, just another thought.
Other questions? Going once? By the way, if you know somebody who's lonely, who just needs more contact, have them seek out the petitioners, sign it, and then every 7 days, there'll be people coming and engaging them. They'll have long-range, big-picture discussions of the future of their town. What a delight for those that just need a little more attention. Any other comments? Thanks, this panel. Boy, that was the right group, wasn't it?